We are all set. Today is Monday. I'm sorry, it is not Monday. Thank you. It is Wednesday, 9:30, December 14th, and this is the Collections Service Board. I will go ahead and turn it over to Mr. Howard to get us started.
And I'll call the board meeting to order and ask Roxana to do a roll call, please.
Thank you. Yes. Mr. Bart Howard.
Present.
Ms. Elizabeth Trinkler.
Here.
Mr. Steve Howard.
Present.
And we have two members that are absent, and we have quorum, so we may proceed. Thank you.
Roxana, if you'll read the notice of meeting, please.
Yes, the notice of meeting was posted on the board's website on December the 9th. It is clearly noted, and we need a motion to accept it, please.
Motion's been made. Is there a second?
Second.
Seconded. All in favor? Aye. Agenda. Have each of us reviewed the agenda? Are there any corrections or additions to the agenda? If not, I'll entertain a motion to approve it.
So moved.
Second.
Moved and seconded to approve the agenda. All in favor? Aye. Minutes from the September 14th meeting. Are there any corrections or additions to those minutes? Those.
So moved.
Second.
All in favor of approving the minutes for the September 14th meeting, say aye. Aye. Director's report.
Here, so the director's report is our financial status. As I mentioned, I think at the last meeting, the look has changed, and so as we start building some of this history, I think the bottom part that compares month to month will help us out. For the month, and this is through the month of October, we have a total revenue of $89,225. Total expenses for the fiscal year so far are $53,705, leaving us with a small surplus of $35,520 and in good shape for the month so far. And then below, we've got some comparisons that are month to month that we can kind of look at. The good thing with this view is it now also reflects the cost back, so we don't see at the end of the fiscal year that one huge lump adjustment for cost backs that include our reviewers' fees or investigations or anything like that or legal. So it's kind of built into each month and gives us a realistic picture of what that $35,000 is. It's really left over. So.
Is there any information or records about how the fines are paid when we charge?
For the civil penalties of the court?
Penalties
yes, I can get that to you and present that separately. We get a monthly report on that as well as what's come in from the consent orders. So I can start presenting that as well. Absolutely.
And I assume that everybody doesn't pay their consent orders, particularly.
Correct.
Yes. And
They sure don't.
past due balance, and maybe there's an agency too.
And then we send them to collections.
Yes, yes.
Drumming up to business when we can here.
So what we will be able to present is on a monthly basis the list of what was collected, and I even can get you the breakdown of what particular cases. Because, as you look at the cases, they're redacted, so you don't know who's paying what. But at the time that we receive the money, then yes, you can look at that.
I'd like to know, particularly if they're active agencies and not paying. I think that's important to know. Okay.
Absolutely. Thank you. So the next thing on the agenda, if no one has any other questions, will be the legal report.
Okay, to get started, I will make a few introductions. I already told Bart this, but I will explain it to everybody. This is my last month with you all. We're doing a new process. I don't think Laura's here right now, but Laura Martin will be the new program attorney, so she will take my place. Laura will be in charge of all your rulemaking, your day-to-day questions from Roxana or the board, and normally the day-to-day questions from Aisha, but that will be changing too. And then we'll have two disciplinary counsels, and that will be Miss Shalina Brown and Lindsay Shepard. And also the new paralegal for the program will be Regina, so she will help them with everything. And basically what they're going to do is Lindsay and Shalina will be in charge of the legal report from now on, and they will handle the case from the day it comes into the building until the day it leaves. So if there's a hearing, they will take care of that just so that they have it from day one to finish, instead of like right now where I have it to begin with and then I hand it over to them if it goes to litigation. So.
Excellent. Excellent.
And there's Miss Laura Martin, actually. So that's who will be, she will be attending every meeting and she'll answer any questions that you have just on a go forward. While we're talking about rules, the 50% change of ownership rule that we proposed got put on the consent calendar for today, so we don't have to present it to the legislature, and it will be effective as of January 23rd, 2017. So, good news. But we will get started on the legal report. The first, we have a represent, and I will let Shalina take care of this if you have any questions for her.
First of all, Sarah, we'll miss you, and congratulations on your promotion. We're very
Just a reorg, not a promotion per se. Just a,
Where are you going?
so I will just take different boards now. So I had 5 right now, but then they put the real estate commission on me, so they kind of redistributed throughout the building. So I'll still be upstairs. So if you need anything, you still have my number. You can call.
We have one leaving, going to Los Angeles.
Yeah.
We will miss her greatly, obviously.
Oh, you are?
Yeah.
And she takes her CPA audit exam on Saturday, so wish her good luck on that.
Wish her luck.
Great luck on that. Great luck on that.
That's the toughie.
You sure about Los Angeles?
So far.
Okay.
Are you taking the test in California or here?
I'm taking everything here, so I'm hoping to get reciprocity when I get out there.
Darby.
We will get started with the legal report. We'll entertain questions, or I know Shalina had number 1, and then I believe Lindsay prepared the last 3. So if you have questions on any of those, they will be more than happy to answer them if you.
Steve, I believe you've written some questions down. I've reviewed them all. I think I agree with pretty much the recommendation, but I know you have questions.
Well, my concern is, at first we were going to fine them because they didn't respond, basically, on number 1. And then they did intensive research as to why they didn't respond, and found that a 1-month employee hadn't carried it forward. Am I on the wrong number 1?
Yours didn't get put on the legal report. Mm-mm.
My copy I have. Yeah, okay. Well, I don't know if you have questions about this one.
I don't think they have yours. I don't think it got put on the copy that they.
This is a represent. This case was assigned to me as a litigator, and it was already for a formal hearing by this board, and I believe you assessed a $3,000 civil penalty against this respondent. What happened was that there was a claim on behalf of a medical provider, and then the complainant referred the matter to her attorney because she was being represented. The attorney contacted the collection agency and stated that you are to no longer contact her. Well, they needed some waiver or authorization from the complainant, and that was never provided, and they demanded that they stop contacting the complainant. Well, that's when she filed the complaint. Now, I've been in touch with the main office of this collection agency, and they inadvertently did not respond because locally it didn't get transferred up to them, meaning it sat on someone's desk. So they were very apologetic, and there's no prior history of complaints. They said they never received that waiver, so they had to still pursue the matter with the complainant. So in light of all the new information that we got from the main office, I am recommending that we close and flag this.
The complainant's attorney, is he okay with the settlement like this? I mean, he may have a civil claim of his own, and would closing it affect his claim?
I believe it would not affect his claim, and I have not spoken with the complainant's attorney whatsoever. They were under the impression that that the collection agency would discontinue any further communications, but they refused just to provide that waiver or release.
I don't think that the money really matters as much as it is the consent. I think that they should, you don't have to have a, what'd you call it, a waiver of
waiver?
authorization? I've never heard of such a thing.
Well, there was PHI, personal health information, involved. So they needed a HIPAA waiver from the complainant. Well, the complainant as well as the attorney adamantly refused to provide it. So they couldn't cease the communications with the complainant concerning the bill.
I guess I don't understand that. They could still communicate through the attorney with the complainant.
Well, the collection agency was contacting the complainant directly, and that's why she filed a complaint.
And the attorney contacted the agency and said, don't call my client again. And the agency continued to call the client or communicate with the client.
Correct, after requesting that they provide a HIPAA waiver or authorization, that they had the authorization to communicate with the attorney concerning the personal health information.
In fact, need a HIPAA waiver?
Yes,
Because can an attorney not deal on behalf of someone with HIPAA law?
in this case, no. This was the collection part of it.
So why does a HIPAA waiver have anything to do with the collection part? Either it's
It-
health information or it's not health information.
Well,
Why would the HIPAA waiver be needed anyway?
Well, in some of the descriptions of the services provided, there might have been some medical information, so they needed that HIPAA waiver.
I'm not aware of a patient having to give counsel a HIPAA waiver so that they can be represented. I don't know whether that's the case or not, but I find it unusual with client-attorney privilege. Why would a HIPAA waiver be required for an attorney to represent a client? and
Only
not see-
because there was PHI involved, personal health information involved.
I understand that.
The healthcare provider turned the information over to the agency, I guess PHI information,
Correct.
all right?
Yeah.
And then the attorney, or the patient hired an attorney and asked the attorney intercede with this agency and the PHI information, I assume. I was not aware, like Steve, that the attorney had to have any kind of permission to speak with an agent because of the HIPAA requirements.
I think the agency is being excessively aggressive in their interpretation of not being able to talk to an attorney who is a real attorney who really represents someone, and saying, I need a HIPAA release, a personal health information release. Now, if it was for some other individual or something, yeah, that's appropriate. But I'm just not aware that I almost, with little knowledge, I feel like they're almost hiding behind the non-written personal health information request to continue to deal with the person, because it seems like, and again, I don't know, I'm not an attorney in the room, that the client attorney privilege and the ability to say, don't call me anymore under our laws, call my representative, is one step above personal health information. It's as attorneys, can the clients not tell you all their personal health information? Do you all get a HIPAA waiver to be able to talk to them?
Typically, attorneys, even in representing in a personal injury suit, get the authorization for release of all medical records and information, so it's not just HIPAA exclusive. But in this case, because there was personal health information and HIPAA was applicable, the collection agency was being extra careful. But it's not uncommon to get clients to sign a medical authorization to allow parties to release information to their attorney.
That, in a PI case, I can see that because there's other people in the office that see it, and that would be a good standard thing to do in that kind of representation. But in a collection matter, saying I can't talk to your attorney, personal health release,
Well, they were asking for the collection agency to discontinue any communications with the individual.
they could call the attorney. They could continue to communicate with the attorney.
Right, but they were demanding the waiver or the release.
I think it's a slippery slope when you think about how many thousands and tens of thousands of accounts that are turned over to a collection agency from a medical provider. That is each of those debtors going to be required to give a waiver of authorization to the agency to receive that information? I don't think you'll get that. And I think when the attorney gets in the middle of it, then if I was the collection agency, I'd hold up my hands at HIPAA and say, hey, I didn't do a thing. The lawyer made me do it. The lawyer made me talk to him. I would have continued to talk to the debtor, but the lawyer wouldn't let me. And I don't think, in my own opinion, that HIPAA requires a lawyer to get a waiver of authorization to discuss medical information with a provider or the agency, who also doesn't have a waiver of authorization.
The agency may have gotten it through its HIPAA relationship with the hospital to take a collection account. But again, that's even thinner than saying an attorney has to have it or we won't talk to the attorney. Under our law, a debtor has the right to say, don't call me anymore, call my representative, and you can't call him anymore, you call the representative.
And actually, under federal law, it's required if they even know or think you have an attorney, they're supposed to contact the attorney and not the debtor.
Oh, yeah, but if you give them notice and say, don't call me, here's my attorney, to hide behind the attorney having a HIPAA waiver and not talk to the attorney, that's a stretch too far to me. And
I've never, and we handled a
We-
lot of
we do a lot of
medical,
healthcare,
and
yeah.
I've never run across this.
Yeah. my company handles a lot of health care too, and
I'd entertain a recommendation that we continue with the $1,000 fine, whatever we call it, civil penalty, and the consent order.
well, can I suggest that if we're out of bounds on our understanding of the HIPAA requirement or the blanket requirement that I'm sure the agency got from the medical provider saying we'll comply with HIPAA, because that's part of the typical contract between an agency and a provider, so you have to sign off on HIPAA and you have to be HIPAA compliant, you kind of have to prove it. If that is in fact a HIPAA compliance step, that's a requirement of HIPAA, that an attorney, an authorized representative, legal attorney, has to have a waiver to be able to discuss a non-healthcare matter. I appreciate the fact that they'll see the information through the description of the services. That's just real thin.
And I'd say that's something that we need to know, because that's
Yeah.
not the way
We're
operating.
we-
That's not the way agencies are operating.
No, agencies aren't operating that way, and we've never interpreted it that way up here, to my knowledge. I haven't been here that long, but that's really unusual.
I believe that because of any risk of, finding out any personal health information, even the inadvertent disclosure, there is a requirement for them to obtain a waiver, a HIPAA waiver.
To
What about-
counsel,
What about when the healthcare provider turned the information over to the agency? Did the consumer give the healthcare provider a waiver? I doubt it.
Well, I believe there's a contract between the medical provider
If it's an emergency room, it's not. If there's some medical services performed with nothing signed, and that happens a lot, then there wouldn't be.
Typically, under a placement contract, an agency that takes healthcare debt, the healthcare provider requires a HIPAA inclusion. The agency has to show they're HIPAA compliant. And so the agency gets to see the information because they comply with HIPAA as the hospital does and hospital staff would. It's an extension of the hospital arm. That I don't dispute that the agency had received the right to see medical information. The stretch too far is to say that counsel, an authorized an attorney who represents someone who has confidentiality requirements by what they do, the agency is essentially saying, I'm not going to tell your attorney anything about this or talk to them because they might see medical information. I have never heard that before, and it seems like it's a stretch too far because there's, not being an attorney, anything I've seen, there's not anything you can't or shouldn't tell your attorney, and they can't tell anybody. So it's kind of like HIPAA times two.
Well, as I mentioned, in any representation that's undertaken by an attorney, they typically mean all sorts of, releases from the client to get information, including things such as, police reports and other things. So on the front end, they've already obtained that authorization and release from the client.
You're saying the client in this case won't give the attorney that release?
No, well, neither the attorney nor the client was willing to give a release for the HIPAA information to the collection agency. They just flat out refused. I mean, this was a simple matter. All they had to do was sign a release and say that, yes, you can turn over any information and communicate with my attorney, but the complainant refused to do this.
I think all we're saying is that if this is your interpretation or someone's interpretation, then we need to know it because this is not the way business is being conducted in this industry. This is not happening.
I would be more than happy to find out additional information and bring this back to you.
It's a separate matter. I mean, for the agency to not accept not talking to the debtor and then requiring a release when someone's the authorized attorney or the legal representative, just my layman's knowledge of that, it's like the attorney speaks with the client's mouth, and they are one and the same with regard to information, and that's generally how I've always thought it was in the world, and if it's not, we need to know as a board because
I think some of the
agencies need to know.
yeah.
The guidelines for HIPAA are pretty strict, so
Yeah, they are.
I would be happy to find out additional information and report back to the board.
One other thing that may be a slippery slope for this is two things. The healthcare providers that I worked for didn't turn over any personal health information. They turned over dates of service and amounts and what have you.
They're
but
saying the description of the what was provided could tip you on what it was. An X-ray for
Chest
this-
X-ray
chest
or-
X-ray for potential cancer
Okay.
would
So,
say.
so an agency has 100 collectors. You don't know who's going to handle that account. Is every one of those individuals going to have to give a waiver of authorization?
More than likely not, but when they have taken the position, they've probably signed some sort of documents, confidentiality or other documents in their terms of employment.
Well, you've worked hard on this, and I'd like to see your study next time, and if it's okay, we'll just table this until our next meeting.
Sure, that's fine.
Okay.
Yeah. I appreciate your efforts on it. That's a really fine line for the agency to take the position, you've got to give me a release under HIPAA, or we're not going to only just talk to your attorney, we're going to keep coming after you. That's essentially what it boils down to.
I don't
Never
know.
heard of that great excuse before.
No.
Yeah.
I don't think we need to check in.
Do we need a motion to table?
It probably wouldn't hurt.
Okay.
We do it at the end of all of them, or do we do it now?
You can do it either way. You can accept it as a
We're
whole.
gonna do
and-
it this one, because that's not a part of, this.
I'd move the table and get more information.
I'll second.
Jelena, will you quickly just read the complaint number into the record so that we,
Sure. The complaint number is 2015-001-481.
The motion's been made and seconded to table this complaint and the disposition of it. All those in favor say aye.
Aye.
Okay. Now, do we start the next series of complaints on this?
yeah, that was my fault. I don't know why that didn't get to Roxana to be put on the iPad, but any questions you have on the next 19?
Make sure my comment is on the correct one.
Talking about your number 1, my number 2.
Okay.
Ends in 941.
I think in the past, we've read out the complaint number. Y'all have read the complaint number.
8911 is my first one on this report. This is the last 4 digits. Oh, well, first
Very
get to the
last-
right
Okay,
place.
that makes sense.
I'm sorry. That helps.
Steve, I've been through a whole meeting and done that.
You're on page 17 on the iPad.
Thank
So,
you. There
What
we
I'll do
go.
is just read in the complaint number and my recommendation, and then questions, no questions, we can go from there.
Yes, ma'am.
2016-03-1941. This was a represent from the September meeting. Upon receipt of new information, council recommends dismissal.
My comment is that I have no objection to council's recommendation, except that to have an employee who's there for only a month and they hire and let up an employee who can't understand that something that comes from our board needs to be moved forward and you just don't stick that in a drawer, that's a level of stupid they need to be made aware of. I know they haven't had any, it says they haven't had any complaints before, but diligent research to find out you've got a negligent employee, I'm glad we could help them. I really don't want to let them off the hook for that, but it's not, it's a reasonable reason, but my gosh.
Yeah, and I've talked to their attorney at lengths, and they are very sorry of putting in very strict procedures on new hires, and be aware that anything that comes from a state board needs to be
Yeah. I'm not sure.
expedited.
I'm not sure what effect a cease and desist or a letter of warning is, but if one or the other needs to go to this company.
And I mean, we could send them a letter of warning because they did miss our deadline for, filing a response. So we could send a letter of warning.
Letter of warning, hire better, or train your people on the front end. I think we should send that. I agree. We don't have to change the fine, but
Do you want to do a letter of warning or a letter of instruction?
I think a letter of warning,
Okay.
that's a pretty serious matter when that happens, and in
But
my
instruct them not
mind,
to do it again.
in my mind, I can't, in my mind, it sounds like let's make up a good excuse why this happened.
oh, yeah.
Okay.
Pretty much, boy.
Ready for the next one?
Yes, ma'am.
2016-03-8191. This is also a representment from the September meeting, and they provided some new information kind of describing and explaining exactly what they do, and they are exempt from our statutes, and so I recommend this matter be dismissed.
Or just,
I think we'll
You
approve
can
them all.
keep going,
again,
do
yeah.
it at the
Yeah,
end if you want.
yeah.
2016-046511. Recommendation is for a civil penalty in the amount of $250 for failure to respond. Just a quick note on that, I did double check, and this was delivered to their front desk reception area on August 15th, so they're in receipt of it.
Had a good employee who could read.
Decided not to respond.
The similarity between 1 and 3 is just too close for me.
2016-047511, recommendation dismiss. 2016-047551, recommendation dismiss. 2016-048531, And just so you know, I double-checked this morning, and they have renewed their license, and so they are in active status with us, not expired grace, as it says there. Recommendation on this one is $250 civil penalty for failure to respond. 2016051-501, recommendation is to be dismissed. 2016051-541, recommendation is to be dismissed. 2016051-561, recommendation dismissed. 2016051-961, I recommended discussion by the board on this one, so we might want to jump to number 10, I believe, on your iPads. I would actually, at this point, recommend that you dismiss this one unless the complainant can provide us with proof that the check actually went through, because it looks like, from what her banker is stating, that the check did not go through after she double-checked it, and so she may legitimately owe this money. And I've talked to her at length, and she's willing to pay if she legitimately owes it.
It's not our place to verify whether she owes it or not. It's up to the bank.
Yeah.
Didn't it say that it went through the first time, or it hadn't gone through? The banker saw it go through once, and then they saw it hadn't?
She called the bank looked, and they said, yeah, it looks like it went through, and then she was getting phone calls. I mean, she was getting phone calls at the office and at home 3 to 4 times a day saying you owe money. And then when the bank went back the second time and looked at the statement later, she said it doesn't actually look like it went through. It looks like it was returned. So
it bounced.
that's what it appears.
Her statement would clearly reflect that. That's not hard to validate.
Well,
Being a chick, you think she might notice.
you know, I agree with the dismissal recommendation.
Recommend she reconcile her bank account.
2016052-971. Recommendation to dismiss. 2016055-291. The recommendation on this one is a civil penalty in the amount of what would be a total of $750. $500 for failing to include a statement in the notice informing complainant that he has the ability to dispute the debt within 30 days, and $250 for failure to respond.
Do you know what our previous letter of warning was about?
I did not double check that one. We could check it if you would like to see if we can figure out the violation.
I wonder if that's because we used to send that letter out, the letter of warning about the 30-day validation.
About the
And
validation.
I wonder if that's the second time they've done that.
Not having a proper validation letter, the initial letter, that's a pretty big no-no. To me, there ought to be more penalties for not having a proper initial notice. That's a huge violation. That's the whole reason for the initial notice, is to let someone know they can dispute.
The 500?
Well, I don't know if it's not just the money, it's if you don't clean up your notices, we'll pull your license, to me. I mean, they need to be put on short-term probation and prove that they've changed their letter by sending a letter later, sending us a copy of their letter. It just has to say that. Typically, insurance companies won't insure somebody that doesn't have the right letters. You remember how all that went with it?
Well, if the federal law requires a $1,000 fine for each one of them, so if they're sending out letters a day or a week or whatever, it could be a $1,000 fine on each one.
One of
Plus
those
attorney fees.
Yeah, if one of those attorneys out there who sues agencies consistently found this, no, I don't want them to find it. I don't wish that on anybody. It would be unbelievably ugly.
We could do what we currently have in the recommendation and then request that they send a letter, their current letter, to us so that we can verify that. And then if it's not on there, we can open a complaint as a commission. Okay.
I think they need to comply with the law. I mean, we're not here to uphold the federal law, but we're not here to ignore it either.
And I would like to know what that letter of warning was about before, just in case that's what.
Absolutely. We can go. You want them to go check that right now for you, Bart?
Oh, ma'am, we're going to represent it next time anyway, aren't we?
Yeah, when we see the letter.
Perfect.
Yeah.
Okay, 2016055671, dismissal. 2016056001 and 2016056002. Recommend dismissal against both. 2016056731, dismissed. 2016060581, dismiss. 2016064241, dismissed. 2016064111, dismissed. 2016063221, dismiss. Questions?
Very well done, writing these up. When you tell a consumer that you're dismissing his complaint, what kind of a general reaction do you get from him? I'm calling my lawyer.
From the complainant or
Yes, the complainant.
It depends on how upset they really are. Sometimes, if we can talk and, explain this is why it was dismissed, or a lot of times we do send them to the video. If there was discussion on that particular, incidents, we'll say, go watch the video and the commission discussed it. Here's what I presented to the commission so that you could see what was presented and all the facts that they had in front of them. And a lot of times it's, there's no violation of the law. A lot of these, that's what it is. It's just somebody that's upset but it's very different reactions on different, sometimes you never hear from them. And
That's a tough one on you guys to talk to those consumers, because they're mad. They're mad. They're so mad that they send you a complaint, and then you tell them nothing wrong.
Just to double check, on your number 1, we're changing to a letter of warning. Number 12, we're going to postpone until next month and find out.
And number 1, the 1481.
And the discussion, what was happening on, wasn't that the one we're postponing?
Oh, and you dismissed that one, correct?
Okay.
Perfect. Yes, and Shalina will represent and get more information for you.
Thank you. Thank you, Shalina. New business? Let's approve the, I'd entertain a motion that we approve the legal report as read and what do you call it?
So moved.
Second.
All in favor of the motion, say aye.
Aye.
Okay. New business?
We have none at this point. I did want to inform everyone that we have our online renewal process going pretty well for the collection agency. So our biggest month of renewals is December. It's 177 renewal agencies, which is possibly even double what some of the months are. We had some issues to work out just because of the number of documents they have to attach, so we've tested it a lot. Aisha has had a lot of phone calls. She's probably memorized the system by now, because we went ahead, as the board recommended, not sent out the paper renewal. Literally, it says renew online and go through this, and then the second page gave some bullet points of the documents they'd need to attach. So it got to working after the second day of tests, so we've gotten about 60, maybe 40-something all the way through and licenses out, so that's good. And about 20 that are missing a document. Sometimes they'll send it with the wrong date or not signed, and so we're going back and forth with that. So of the 177, I think it's still a relatively high number that hasn't renewed, but many with the change in the rules may not be renewing. But I wanted to let everyone know that it's available online now, so moving forward, all of our renewals for the agencies will strictly be walking them to the core.tn.gov, where they'll be renewing online.
How was the response of the requirement to go online to renew? Have you got any feet pushed back on it?
I think it was fine. No one complained about going online to do it. It was more the problems with the online system. We had some bumps, and the vendor had to help us work those out and figure out why it wasn't going online. We actually had to walk through a few agencies, getting on the phone and going through. So there was some uniqueness, and we think somehow tied to the volume and the number of documents that needed to be attached, but we never quite could put our finger on it. But it appears to be working now.
Right.
So the hope is the months moving forward, people won't get stuck. So we did have some that if they reach out to you or to us that, tried several days until we could get them to to get it to work. So none, I don't think, or not many gave us the push for, we don't want to do it online, we need the paper, right?
I think this board is set for two reasons. One is to protect consumers, and the other is to encourage the industry. Anything we can do to forward our industry, then I think that's what we should do. So, good work. Thank you.
That business about HIPAA we're going to look at, that does
Absolutely.
forward the industry. That's really concerning if that's a requirement
Right.
to get an attorney to give a waiver.
Right. No, we'll definitely look at that and update with the case what that really requires attorneys to do, so we can inform the industry if we're missing something, so. Okay, anything else?
Welcome, new ladies. Bye-bye, old one.
I have 3 quick questions.
Okay.
The first question is, can companies have aliases and register them for each solicitor within the state of Tennessee?
Say it again, please.
Can companies have their solicitors have aliases and register them when they renew or put in an initial application within the state of Tennessee? From what I've researched, some states it's illegal, but in others it's a requirement. But nothing in Tennessee says.
Collectors, I guess, is what.
For collectors or solicitors?
For the people calling saying you owe this debt.
Collectors.
Collectors,
Mm-hmm.
okay.
They have to have a solicitor card?
No, the solicitor card's somebody who goes out and calls on clients, I think. You have to have a card for each one of those. A collector, I don't believe, is a solicitor under our rules. I could be wrong.
Well, per the rule, a solicitor is anybody making any contact in regards to a debt. So that could be via mail, via email, calling, etc.
And what your example was is that a solicitor was planning on using an alias when they were making phone calls. And I don't think anything in our statutes or rules covers that. But Aisha did some research, and like in Texas, you cannot use an alias. So I can't call and say, this is Steve Harb. I'm collecting on behalf of, I have to say this is Sarah Matthews. So that may be something that we want to.
I think you've
Look
raised
into
even a
and
bigger
consider.
question, and that is do collectors have to have a solicitor's card? If you got 100 collectors in your shop, then that was a solicitor's card, $25?
$25 for each
Correct.
card. We'd never charge for each collector. There's a fee based on the size of agency you have. No, that has to do with the bond. But we've never charged a solicitor's fee for every collector. Somebody with 200 collectors or 200 people, that's a lot of solicitor's cards. That's a whole new thought.
Our definition has always been soliciting new business and a
business.
salesperson.
This says a solicitor means any individual who is employed by or under contract with the collection service to solicit accounts or sell collection service forms by systems on its behalf.
Well, then that's not a collector.
So it's the
solicit
one reaching
account
out to
means to buy
the client
accounts.
saying, we want your
Right.
debt so that we can collect on your behalf.
They would have used the word collect accounts as opposed to solicit accounts. You already have the account when you're calling to collect on it. You don't have to solicit receiving it.
Right.
Unless
So was it a solicitor that wanted to change there?
She said solicitor. That was what she said.
I mean,
Some states
That would be-
require each collector be certified or what have you, and that what the agency wants to do is they want to buy John 1, John 2, John 3, John 4, so when the collectors leave, they don't have to buy a new card. They just go, okay, you're John 1, and that way. And I think that's where the question came, but I've never felt like that a solicitor's card was for each individual collector. I thought it was for my salesperson.
Yes, yeah. That's
And based on the language that Sarah just read, that's how it should be interpreted, and that makes sense because based on the number that the agencies are giving us,
It looks like sales.
it's lower, yeah.
And it's
that-
still a
that
fair
looks right.
question
Yes.
to ask,
So is that what
can a
Bart's-
solicitor have an alias?
so that's what Bart was saying, that
Right.
they would just say it would be like John 1, John 2, and then when you came in, if John 1 was gone, you're now John 1.
As a solicitor?
I think the solicitor's card came about in 1971 when the act was first passed to prevent people that are not actually selling for licensed agencies to sell. I'm not sure I had a solicitor's card for every salesperson I had. I don't think I
anybody
did.
ever was asked to
But
see
the
one.
open question is can solicitors have an alias? And do they have to register it? And I don't know. I can't imagine somebody actually selling accounts who doesn't use their real name to be contacted. It's alias. I'd be inclined not to let a solicitor have an alias, unless they were on the phone dialing, then they can have an alias as a dialer, as a collector.
I suppose so, if there's a reason for that. But I think the question was posed because we thought solicitors were also debt collectors. And I think that the way they asked you the question is confusing, but maybe it's one of those things that we don't need to ask, we don't need to tell. We just, I'm not sure that there's a question as far as what we determine to be a solicitor, whether they can use an alias or not.
Because, I mean, your answer would be, according to the statutes and rules, there's nothing that prohibits them from using an alias. So I think that goes back to Steve's question. Is that something that we want to consider in the future?
And part two is you ought to let them know that a solicitor is not a collector, just kind of as an aside, that it's a different thing. They may be misunderstanding that. But Bart, is it something worth considering to not let solicitors have an alias?
Gosh, I don't know. We have to go to the Hill and get that done and all? I mean, how much effort is in that?
It could probably be done by rule.
Especially if the board thinks that we shouldn't allow it, because right now, by it not being in there means you're leaving it up to the agencies to decide how to use these.
I don't think they should have
An alias,
an
no.
alias, no.
Or bother to get a card and register somebody. You need to register their real name, and they need to go out and represent who they are and the agency they're with. I mean, you get an alias name, you're representing an alias agency.
I think that they should not be able to have, a solicitor should not be able to have an alias.
But a solicitor is defined as someone who sells for accounts, not someone who collects on accounts. Let's clear that
Need to
up, too.
understand that.
Okay.
We don't want to go down that road and then have it be
But then-
unclear.
Right.
Any other business?
My other two questions.
Oh, for goodness
Sorry. Can collection agencies collect child support within the state of Tennessee? From what I researched, there is like a child support enforcement within the state, and it would typically be up to the families to choose if they want a collection agency to go after that account. But I didn't see anything in our statutes.
I used to collect child support. I mean, it's not good business, but
I don't know why you couldn't collect anything if you're collecting it legitimately
It's
and
illegal.
following all the collection rules. It's a debt that's legally owed.
I don't think we have anything that prohibits
Yeah,
that either,
yeah.
so.
And then last question, can collection agencies come to your home in regards to a debt to collect on it?
I don't think there's anything in the statute that prohibits it. I wouldn't do it, but
Door knocking opens yourself to so many other harassment problems. That's a bad choice. But to go knock on doors and collect, folks used to do that a long time ago. Door-to-door collectors.
I think there might be a federal rule that got passed in October prohibiting it. I might have to do a little more research, but I would say no, because if you go to somebody's house, you don't even know if that's the person who owes the debt, and then you open yourself up to asking
I
questions.
hope it's prohibited.
Okay.
Because I don't think it's good business.
I don't know
I don't think it's
statute, but
good
it
for our
makes sense
industry
that
to have that.
It'd be something to add to those rules you're looking at.
That's
is-
probably something you and I should get together on.
Yeah.
Yeah, we can figure it out and have something at the next meeting for you all. Well, Laura will
Your
have
next-
something
your
at the
next
next meeting for you all. You're in good hands, though.
Are you through? Okay. I move we adjourn.
So move second.
There we go. All in favor, say aye.
Aye.
Thank you.
Thank you.